this class, we took an in-depth look at contracts, both in general and how they work within the real estate industry. We began with fundamental concepts, including the legal foundations of contract law, and we examined what makes a valid contract. We also discussed performance and interference, and took a look at the consequences of breaching a contract, and addressed some general considerations to keep in mind when building one. Then, we got into the standard contracts used in the real estate industry, and looked closer at purchase and sale agreements. We then moved on to important considerations including documents that are commonly attached to real estate contracts, earnest money deposits, contingencies, date of possession, and contract expiration. And finally, we discussed which real estate contracts are used in Michigan, along with how they're used. At their most basic level, contracts are legally enforceable agreements between two or more parties. They come in two general forms, written and oral. Written contracts are superior to oral contracts because written contracts have a greater degree of certainty than oral contracts. To be valid and enforceable, contracts must have certain minimum requirements including parties with legal capacity, an offer with intent and a definite statement of terms, a valid legal purpose, an exchange of consideration, and an acceptance by all relevant parties. We also looked at when a contract can be unenforceable. If the purpose of the contract is illegal or goes against public policy, the contract is void from the moment it's formed. A contract that's otherwise valid and legal but has a major flaw is considered to be a voidable contract, since it can end up being canceled. This applies to contracts where there was a mutual mistake or where one of the parties lacked legal capacity as well. After contract formation comes performance. In this step, the parties to the contract are required to complete their obligations as specified in the contract. In reality, performance is complicated by conditions, also known as conditions precedent. These are tasks that must be completed prior to a party carrying out their contractual obligations. A condition precedent in a real estate contract would take the form of something like, the seller must have the property professionally inspected before the closing. In this case, if the inspection isn't completed before the closing, the buyer may be allowed to back out of the sale. A breach of contract is where one party fails to complete their obligations under the contract. A breach of contract is commonly dealt with by a lawsuit, where the party that committed the breach is sued by the other parties to the contract. The amount of damages that can be requested from the breaching party depends on the severity of the breach. The remedies for breach can be legal or equitable. Legal remedies are all some form of monetary damage award. Equitable remedies are actions related to the contract, like maybe canceling or reforming the contract, or forcing the breaching party to complete their obligations by the contract. In the real estate industry, you'll be working with some fairly standard types of contracts, which can usually be divided between listing contracts and buyer representation agreements. Both of these types of contracts can be further categorized depending on whether the client is working exclusively with the broker or not. The real estate industry runs on contracts, and almost nothing happens with real estate or real estate agents without some kind of written contract in place. When it comes to transactions, the most common contract you'll deal with is the purchase and sale agreement, known as the buy and sell agreement in Michigan. While it might be nice to imagine a world where a person's word was all that was needed, that is not the world we live in. This is especially true of the real estate industry. Real estate transactions involve too much money and carry enough risk of harm to leave things to the word of the people who are involved. No. As a real estate agent, you will rely on formal, often standardized written contracts. If something goes wrong or someone doesn't do what they're supposed to do, the contract will form the baseline for settling the dispute. But this isn't just to protect the clients from the person on the other side of the transaction. Written contracts protect you and your client from each other. A written contract ensures that you do the work you're assigned and you're compensated for your work. Contracts are the foundation upon which the rest of the real estate industry sits. This concludes the fundamentals of real estate and real estate agency. In the next class, we'll explore property ownership. Thank you for choosing At Your Pace Online.